Welcome to the Consumer Finance Podcast. I'm Chris Willis, the co-leader of Troutman Pepper's Consumer Financial Services regulatory practice. And today we're going to be talking about a grab bag of hot topics in consumer finance with a special guest providing in-house perspective on those trends. But before we jump into that topic, let me remind you to visit and subscribe to our blogs, TroutmanPepperFinancialServices.com and ConsumerFinancialServicesLawMonitor.com. And don't forget about our other great podcasts. We have the FCRA Focus, all about credit reporting, the Crypto Exchange, about all things crypto, Unauthorized Access, which is our privacy and data security podcast, Payments Pros, which is our podcast all about the payments industry, and finally, our newest podcast, Moving the Metal, which is all about auto finance. And all those podcasts are available on all popular podcast platforms. And speaking of those platforms, if you like this podcast, let us know. Leave us a review on your podcast platform of choice and let us know how we're doing. And if you enjoy reading our blogs and listening to our podcasts, our mobile app is a great one-stop shop to do that. Just look for it in your app store under Troutman Pepper. It's available for both iOS and Android. Download it and give it a try. Now, as I said, we're going to be talking about a grab bag of hot litigation and regulatory topics in consumer finance today, and I'm joined by two guests today, which is a real treat for me. First, I have my partner and longtime friend, David Anthony, a member of our Consumer Financial Services group here at Troutman, and our special guest, Rami Haddad, who's been on our podcast before, and I'm glad to welcome him back. Rami is the Deputy General Counsel for Compliance, Litigation, and Privacy for PRA Group. So David, Rami, thanks for being on the podcast again.
Glad to be here.
Thank you for having me again.
Let's start the discussion by talking about some interesting litigation trends that are going on in the consumer financial services industry, because there's really a lot going on there right now. Rami, do you want to get us started on this topic? I mean, what do you think is going on from your sort of viewpoint of the industry in the litigation sphere?
Statistically, and public records indicate as such, and it cuts across the industry of financial services. I think over the past year, we've seen usual consumer financial protection laws, such as the TCPA, FDCPA, and FCRA. Those filings, trending up month over month, generally speaking, with some historically high months over the past year. I would say we've seen there are other buckets of laws that have been, used in litigation this year. And, we've seen some VPPA, the Video Privacy Protection Act, SEPA, BIPA in Illinois. Those tend to privacy and has been a hot button issue in litigation over the past year as well, with contributing to increased litigation costs, settlements across the board. You'd be inclined to say, well, macroeconomic trends and leading to higher settlements potentially, but the statutory damages are still capped. Actual damages don't trend with macroeconomics. So really, you're left with sort of what's contributing a lot to potentially higher settlements and costs of litigation. We see that as tending to be more on the attorney's fee side of things, because as we know, a lot of these laws have attorney fee provisions, right? So higher inflation labor market for associates and partners and so on, I think tends to add to the settlement costs and litigation costs of these actions that are trending higher over the past year.
I would just amplify a couple of things, which is the cases seem to, generally speaking, be increasing. Sometimes it might be one category over another versus one, but they're not going anywhere. Similar to that, I think there's a macro trend and a micro trend in my view. I think back to 10, 20 years ago, you had 3,000 cases 20 years ago. The nature of those 2,000 cases is dramatically different today than it was 20 years ago. And you might have had a lot more former legal aid type folks who are bringing claims, whereas now the sophistication of the plaintiff's bar has changed radically. So it's apples to oranges to say that the number alone has relatively stayed stagnant or is modestly increasing, when I think you also need to look at the caliber and nature of the cases that are being brought by whom. That to me has had an impact. I think just as a general proposition, the cost of litigation and the settlements have gone up because the plaintiffs have gotten more aggressive in that sense. Cost of litigation is expensive and it creates attention for clients in terms of defending these cases and just the sheer cost to defend it. And I had this conversation with a client where they said, what is the client? Are they trying to bankrupt us with this claim? And I said, no, they're trying to get $1 less than that. And the plaintiffs' counsel are certainly pushing and being more aggressive in that sense. There's some other things I think we're going to talk about, but at a very high level, those are two things I'm seeing. And then the third thing I would say is there continues to be creativity by our plaintiffs' counsel to either see a dry well in one area and come up with a new theory or change different claims, something else. or to attempt to manufacture a new claim. Let's take a failed FCRA claim and create an FDCPA claim, or a failed FDCPA claim and create a TCPA claim, or a failed TCPA claim and create a UDAP claim. So the field is kind of shifting consistently. There are some steady old reliables, as Rami knows well. There are some steady players who have their problem finding 5, 10, 20, 30 claims, and they bring a dump of those claims, and then they run their cycle. And it seems like every year there's groupings of that, and that's continuing.
I would agree with that. I think we've seen also probably an increase in self-represented consumers, pro se's. On average, I think 10 to 15%, as I last checked, were pro se filings in the consumer financial area. Rather, the majority end up actually being comprised of prisoner petitions, right? So the overall majority is on the criminal side, but 10 to 15% tend to be more on the consumer financial services side. What we've seen, however, in that space with self-represented individuals is potentially a higher level of sophistication in terms of pleadings, legal research, motions before the court, things of that nature. I think emerging technology has certainly fueled that. And here, and I specifically mentioned artificial intelligence, for example, things of that nature that are now publicly available. I think we've also seen some players in the industry who have come on to the scene where they offer potentially fee-based legal help. We've seen a lot more of that. And I think that's also contributed to more of the self-represented cases that we're seeing. I think also we've seen an increase in sort of what we call the more frequent consumer plaintiff attorneys and plaintiffs themselves who are repeat filers of claims. On average, I think last I read statistically, about 40% were repeat filings by the same number of individuals. And we've also seen a lot of sort of what we call manufactured sort of claims by consumer law firms and credit repair organizations that tend to work closely with them. Some of these are standardized letters that are sent containing vague language buried amidst a long text. I think a recent case out of Pennsylvania, in which actually Portfolio Recovery Associates LLC was involved in, highlights that fact. There was a firm there in this case where PRA was a defendant. That firm was publicly chastised and sanctioned for writing letters on behalf of their clients using standardized handwritten letters that included a lot of irrelevant text along with vague sentences buried in the middle of the letter, reciting an even less conspicuous and very arguable mention that the consumer does not owe the money, in which is subsequently alleged to be a dispute. That was out of Federal District Court of Pennsylvania.
Yeah, I'd echo Rami's comments and add just a couple of other observations on top of sort of increasing technology. There seems to be a rash of folks on YouTube and social media who will tell you how to file consumer claims, and having seen some of them are accurate and some of them are not accurate, but nonetheless, the combination of all this is resulting in more pro se claims. I had one client who's had an almost 50% increase in the pro se claims. And, again, there's nothing wrong with having self-represented individuals, but if you understand, particularly if you've got a seasoned consumer plaintiff's attorney, you can have a frank conversation because you know them. You can talk about the merits and sort of get to the claims. And sometimes there is misunderstanding on either side, but you can kind of touch the heart of it. As everyone knows, when you have a pro se litigant, the rules are slightly different. Some courts have special rules, and courts tend to give some latitude. So, sometimes that just creates more of everything to get all that resolved. The sort of last point on the pro se litigants is there are some repeat players. There are some more sophisticated folks that are happening, but it does, when you're having an increase and you're having an increase of pro se cases, that creates different challenges for clients just to deal with from the volume perspective.
Well, let's shift away for a second from litigation and talk about some more regulatory type issues. And Rami, I'm particularly interested to get your viewpoint on the next thing, which is earlier this year, the Supreme Court overruled Chevron in the Loper Bright case, potentially sort of ushering in an era of less federal court deference to agency interpretations of statutes. And in consumer finance, we have a lot of agencies and they do a lot of interpreting of statutes. And so I'm very interested to hear what you're thinking from an in-house perspective about the potential impact of the overruling of Chevron and Loper Bright and how that may sort of impact the industry as a whole going forward.
Yeah, certainly coming out of this recent Supreme Court term, that was arguably one of the more seminal cases that was released this year. We obviously, 40-year-old precedent under Chevron overturned. Yeah. And just for context, under Chevron, if the Congress had not directly addressed the question at the center of a dispute, the court would have been required to uphold the agency's interpretation. And of course, now that has gone by the wayside. And now we have that deference pretty much in the hands of the courts and the judges, right? So it's a major transfer of power, I think, from regulatory agencies to judges. What is the impact? What could we see? I think it certainly jeopardizes a regulatory agency's ability or to maybe promulgate regulations just for the fear of potentially being challenged or struck down by courts subsequently. I think you will see regulations challenged even more regularly now than they were in the past 12 months, and we've seen many that have been challenged. I think you'll see them challenged directly, potentially, or under the APA, for example, or collaterally in a private lawsuit. I think you'll see also potentially impact to the regulatory policy lifecycle. So how are bills drafted? What delegation language? How regulated entities and the comment on the rules that are notice proposed rulemaking and how they comment on those rules before the agencies. There's certainly big shadow of doubt on the validity of some of the existing agency interpretations, even though that the ruling did not undo those prior interpretations. I think, generally speaking, you're just going to see rulemaking be under heightened scrutiny and under a microscope. In fact, I think since June, we've already seen challenges being made as a result of Loper, from things related to airline fees, to gun sales, to other matters. Yeah.
Yeah, from my perspective, I agree with Rami. Loper was a very, very significant decision, but I think will have an impact in many consumer financial services statutes. And if you think, like, let's take the FDCPA or the FCRA, for example, or the TCPA, these are statutes that were written some time ago. And I use the word interpretation with air quotes because, in my view, part of the problem that the Supreme Court identified in Loper was that interpretation was effectively rulemaking or legislation. And so I do think there are distinctions between what it is that the federal agency is saying. But, with this particular CFPB, for instance, they take an aggressive view of interpretation. I heard a commentator shortly after the decision came out make the comment, having previously been a federal regulator, that it used to be that a federal regulator would say, this is what we want to do. Let's see if we can find any sort of hook in a statute to do what we want to do. And this sort of warps that to make them have to start with the language, which then of the statute, which then restricts them in terms of, let's just use the word creativity, in the aggressiveness of what they can do or get away with. I do think that there's going to be very, very close scrutiny. You can certainly see this in any new rulemaking, that there are going to be challenges. I know with the FCRA rulemaking, I saw several comments specifically about the authority that the CFPB was attempting to discuss or regulate was beyond what their purview was by the face of the statute. So as Rami said, you certainly can see there being litigation challenges to this, which will affect the timing of rules as well as the scope of the rules. The other thing, too, that I would add to that is that I think will be a real change in things is part of the reason that these agencies or the federal government, the executive branch, has made executive orders or agency interpretations or rules has been because there has been a logjam in Congress. Congress has been happy to sort of operate under the Chevron rule, make a general rule, and then leave the details to the agency. In some instances, that agency is conservative, in some instances, that agency is more aggressive. So you can see this actually changing the nature of the legislation itself as well. And so do we want a FDCPA, for instance, that's 200 pages long? I'm not saying we do or we don't, but the way that Congress has been legislating is going to have to change to address this. The last point I'll make is I think back to where there was a lot of conversation, how people thought that the world was going to end when some more conservatives took over or began to be more influential as to constitutional interpretation with originalism and plain language text interpretation, or when the Troutman-Iqbal cases came out about pleading, or when the Article 3 cases that came out, Supreme Court came out when the reality of all of it was it caused a shift. And so for as much a sense that some folks had that this was simply a tool for the defense side, it's a tool for lawyers. And so in my view, it has changed as well how plaintiffs plead cases. I've seen plaintiffs' counsel argue originalism in plain text that you never would have seen 10 years ago. There is different litigation strategies to take advantage of the Article 3 standing rules and to perhaps keep a client as the defendant in state court as opposed to in federal court. So I don't suspect that the plaintiffs' bar and the agencies are going to sit idly by. And I certainly expect that there's going to be some two-way streets to this, but as well to that, I think there's going to be a lot of sausage made in the next 5 to 10 years while this gets sorted out in litigation.
Yeah, I would agree with that. As one last comment on that before we move on is that Congress's legislative efforts, the intent there, right? The ambiguity of the language, let's just say that, is not always unintentional, right? And so now there's going to be a level of sort of surgical precision almost required by congressional legislative intent in public policy making, right? So that's certainly a shift in how public policy and bills are proposed. Now, speaking on the authority, that probably segues into another topic we're going to talk about shortly, but you can see how, for example, in the TCPA, that fueled decades of litigation. I mean, it was a matter of syntax, right? And just that alone, how prevalent litigation was under TCPA. And it was really a matter of how words were arranged in the sentence and where the comma was. So that's the sort of precision and the level of unambiguity that it's going to be required going forward.
I'll add one point that I'll give Chris credit for this comment. I mean, I've heard him say this in other podcasts as well as in conversations we've had. There are a lot of folks on the defense side and the industry side who thought that Chevron, as it has developed, was sometimes a really bad thing. Now, but the flip side of all that was, in many instances, Chevron and this sort of rulemaking idea did provide predictability for companies. And so I do think that some of that is going to be up in the air in terms of companies who have set around their compliance strategies based upon some of this regulatory advice. And, are they going to not honor that anymore, or are they going to be a competitive advantage or disadvantage if they honor the old Chevron advice while all this stuff gets sorted out? I hear that from clients in a sense of, okay, so what do we do about all that? And, most of my clients like certainty, and having uncertainty certainly is disconcerting for businesses in terms of how they operate on a daily basis.
So this has been a fascinating discussion about Chevron and the impact of it being overruled. But there are a couple of other hot issues that I wanted to have us discuss involving a couple of sort of CFPB initiatives. The first one that I've been getting tons of client inquiries about is the CFPB's nonbank registry rule that essentially was finalized earlier this year and requires non-banks to sort of register any enforcement orders that they have with the CFPB or with a state regulator if the subject matter of the order is sort of a consumer financial product or service and one of the laws that the CFPB specified in the rulemaking. Rami, what's your perspective on how you think the existence of that registry is going to impact the industry?
That's a great question. I think for the most part, most non-banks that are going to end up being covered under this are certainly grappling with the same concept of what is this, why is it needed, and what will come of it, what ramifications will come of it. Certainly I think the CFPB and under Director Chopra specifically, there's been a big push to reduce sort of repeat offenders or corporate recidivism, right? Such that, quote, I think the Director Chopra said the penalties for illegal activity as the cost of doing business, sort of, that is not acceptable, right? And so the consent orders are, to the CFPB's point, not polite suggestions, right? So the intent, I think, is to make them publicly available and more easily tracked, as they are not necessarily now, specifically because current registries, such as the NMLS specifically, which is the most widespread, a lot of entities that are non-banks may or may not be licensed and have to be registered to NMLS. And so any orders against such entities may not be tracked. So that's one of the reasons that I think the CFPB has cited, in addition to the corporate repeat offender, corporate recidivism rationale, and the fact that I think financial companies, they cited, that have not faced consistent oversight. And so it makes it more difficult for regulators, not just the CFPB, but also cross-agency, to identify and address risks across the industry. So those are some of the reasons the CFPB has cited to that. It is yet to be seen how this will impact non-bank entities that are covered and must register any covered orders as that's defined by the rule. I think at best, there's reputational damage to be considered, right? That may be associated with being labeled sort of as a repeat offender, if that's what this rule is intended to do. I think certainly other companies looking to do business with non-banks and doing their due diligence may also use this to look into the company and any orders related to them. It may also sort of add fuel to that fire and that the company is not doing what it should be doing, right? So those are some of the things that are top of mind. It's very hard to tell how this will play out. I know that House Republicans have challenged the rule, specifically under what David was just mentioning a minute ago, was under the CFPA authority, that CFPB does not have the authority to do this specifically. I'm not sure if that challenge will materialize, but again, that's as best as we can tell right now, is that it will also require, of course, just as anything, higher costs of compliance. There are multiple steps you need to do under this rule. And there are also some, I would say, somewhat onerous attestation requirements on an annual basis and so on.
Yeah, and I would agree with Bum's comments. Currently, there's no central repository for all this stuff. So at least when you're defending someone, sometimes there's not a concern that's sure going to be public or easily found publicly. So that might play a role in the litigation or settlement strategy. But I also think that personally, if this plays out like I think it's going to play out, if it's adopted, I do think that it's something that's potentially a negative that's not a major negative to folks in the industry. So you could see that changing the approach to litigation. It's one thing to agree to do something or even have a consent order, which, in many instances was easier than fighting on litigation, but more particularly where there is a frontal assault right now being made perhaps on the scope of the CFPB's authority to do certain things. You could certainly see companies saying, well, the advantage of a resolution is not worth the tar and feathered forever and being part of its registry. So we're going to go litigate this issue or litigate the authority issue. I also think that I think about class action lawsuits. One of the things from the private litigation perspective that you always worry about, particularly if you settle a federal court case on a classified basis, is the TAPA notice that you have to give to state attorneys general. And looking back over 10, 15 years, there is a trend of having more federal or state regulatory investigations that follow from a public class settlement than without that. I have more clients now who 5 years ago wouldn't have really worried about that, but now that plays a role in terms of when is the case over, because most regulators will say that the class action privately does not extinguish our authority or our rights or our remedies. And so if you add this to that, that's another feather, at least that would cause hesitation between a public versus private settlement on the litigation side. I also have to believe that, there's already some cynicism about self-reporting. If you're going to self-report and you're going to end up with a consent decree of some type, if you had an aggressive regulator who said, we want to document each and every instance of that, I could certainly see that being another factor that they would have to decide. The other thing, too, is much like some of the efforts that have been made for the CFPB Consumer Complaint Portal, there's always a concern that this will contribute to some type of argument or finding that somehow the defendant's behavior, why its behavior is willfulness. And you can imagine certainly seeing a plaintiff's counsel arguing if there's a string of 3 or 4 or 5 items in a registry or a company, you certainly would expect to see that in a jury argument. Those things are less about the technical element of the registry than what I see might be some of the ramifications of the registry.
I agree with that. One last comment on that, and you really hit on a really good point, David, is that does the fact that the registry exists, does the fact that you are required to register on the registry, will a non-bank be less inclined to enter into future consent orders or decrees? And so that then sort of parlays into our earlier conversation, challenges to regulatory agency authority. So would a non-bank now be more inclined to sort of challenge the regulatory interpretation under which they're being challenged for purposes of the consent decree? And so it all kind of parlays in together. So it's really fascinating, yet to be seen what will come of it.
Yeah, I agree, though, with both of your comments that the primary impact of this rule is to basically increase the impact of a consent order by triggering more of what I'll call the pile-on effect, either from other regulators or from private litigants. In fact, I think that is the purpose of the registry rule. And so it means that Today when people enter into consent orders, it's not that common to see other regulators pile on afterwards or private litigation pile on. It happens sometimes, but not all the time. And I feel like the registry is going to cause both of those things to happen much more frequently.
Yeah, and I'm not going to suggest this is the case, but you certainly could see how a federal or state agency or head who happen to have a more aggressive political agenda on a particular industry could effectively try to choke point a member of the industry or an entire sector by overwhelming them with consent decrees in order to taint the entire industry.
Yep. Well, there's one more hot topic that I'd like to cover with you two gentlemen, and that is with regard to debt collection. The CFPB in particular has been incredibly strident recently in public statements and actions related to medical debt collection. There have been two enforcement cases. One was at the tail end of last year, one was earlier this year. You've seen numerous sort of reports and press releases about the perceived evils of medical debt collection. And those just keep coming. And there was even a White House event where the director of the CFPB went to the White House to talk about what the Bureau is doing with respect to medical debt collection. And so, Rami, you're a veteran of this industry. I'd really love to hear your impression of what's going on with this very high degree of focus on medical debt collection.
Lots going on, right? Obviously, it's hotly publicized. There's a lot going on with it. You're going to see news coming out. We just saw that yesterday, like you said, related to the proposed rule to prohibit medical debt from being credit reported with the credit reporting agencies. A couple of things here. I think there's a public policy aspect to this as well, in the sense that medical debt has increased. You can see that it now contributes to a larger piece of the pie of the consumer financial debt nationwide. There seems to be obviously issues with the health system. So the CFPB is taking a position that a lot of people suffer from medical debt. It's comprising a lot of the national debt for most consumers. But also one of the rationales for that is that it's rife with inconsistencies when it is being reported or collected upon, right? That there's a lot of inaccuracies and that it's really a poor predictor of whether someone is likely to pay their other bills and loans in the future. I think the issue with the proposed solution is sort of the old adage is the cure going to be worse than the disease, right? In the sense of what would happen, and we've seen this kind of play out before. This is not somewhat analogous to the proposal to eliminate a certain portion of student loan debt that we saw in the past. And are we really getting to the bottom of the issue though, right? Are we really fixing a broken health system? Are we really addressing the cost of prescriptions and medical devices and goods for individuals? That we're really that's the real issue, as opposed to sort of saying we're just not going to report medical debt. And so yes, will that give a reprieve to millions of Americans? Sure. I don't believe that really fixes the issue that's systemic in our society with related to this issue. I think what you'll see is the same argument we've seen in the past, which is, okay, now that you've done that, what happens? Medical debt, unlike other consumer debt, it doesn't subscribe to the economic laws of supply and demand, right? People are not going out and choosing to buy medical debt. They're not choosing to buy such like they would a television or another consumer good. So medical debt is just something that happens to you, right? So the demand is what it is. It will always be organic. The problem is then will become the supply. Our lenders, our healthcare providers, are they going to be inclined to basically extend the same amount of credit? Are they going to ask for money up front for services now, right? Is it going to lead to individuals potentially looking to other sources for lending, basically unscrupulous potential actors or other mediums that will higher interest rates, higher payments, and really does a disservice to the consumer at the end? Because no matter what, if they need a medical attention, they need medical service, and they're going to need to get it, and the cost is the same, how are they going to pay for that? And I think that's where the argument is potentially the cure maybe end up being worse than the disease.
Yeah, I would echo, certainly there's a public policy element to this, and that's the American healthcare system and how all that operates. And it's not exactly the easiest to understand, but certainly there are folks on the more progressive side who want a single taxpayer system or single payer model. That certainly there can be an argument that this is another step for folks trying to make that happen. But at the end of the day as well, I also think there's some diswall politics about this. It's popular. It's good from a voting perspective to eliminate debt, whether it's medical debt or student debt people have. I think Rami's spot on in the sense that it's not answering the question here. But again, there are folks who have debt who choose not to credit report because the credit reporting system is voluntary. The credit reporting system is complicated. That doesn't mean that the debt was gone away. And so, one of the things that struck me is that the notion that somehow the medical community or the lending communities that remain static with whatever it is, I think is a bit folly, to the extent that there have been other things that have been have done that have the net effect of increasing credit scores, and whether that's some of the mortgage loan modification programs or it be the inclusion of utility bills or other things. It's not like the underwriters aren't aware of that. They've made adjustments, what they think is a minimal credit score that would be sufficient for someone to qualify for whatever the loan happens to be, because at the end of the day, the underwriting criteria look at things like amount of debt and those kinds of things. So I certainly think that if this ends up going through, there will be ripple effects along the lines of what Rami said. I also think this too, a cynical view of all of this is that the CFPB recognizes that the FCRA rulemaking in toto is never going to be approved. And so let's pick one or two things that we really want to harp on and see if we can't create enough political support behind it to either make that happen or to have Congress do something. And clearly, medical debt is one that seems to be at the forefront. I don't think there's any great surprise as well that the timing of this relative to the election is on purpose. So it is a to be decided, but Chris, you're spot on. It does seem to be obnoxiously present in a sense of just the volume of stuff that's coming out seemingly on a daily basis about this. And there's a lot of other stuff in the FCRA rulemaking that is causing a lot of interest, but this one is dominating in terms of the volume that seems to be attention that seems to be getting to now.
To add to that, David, I think there's one other aspect of this that's important is that so the CFPB's intent is to close what they argue is a loophole in Reg V related to this issue. However, they have publicly come out and we have seen statements from them directing states to feel free to enact their own laws related to medical debt, and they have, in fact, stating that FCRA is not preempted, state laws are not preempted by FCRA in this instance. And we've seen Colorado, New York, and Minnesota pass specific legislation targeting medical debt and credit reporting of such debt and other requirements that are related to that. With the issue that happens is you may end up, even though you close the loophole at a federal level, you may end up with a 50-state patchwork of different laws targeting medical debt in different ways in those respective states, including how medical debt is defined, right? So that'll be interesting to see.
That's a great point, Rami. And there's the same worry about Loper. A lot of things that the CFPB, for instance, or the FTC or federal agency would not be authorized to do, a state might do. And, we've seen a lot of that. There have been a lot of states that have done this on the FCRA side in terms of credit reporting. Their fights have gone on around the country about FCRA preemption, those kinds of things. And also, I would say, Chris may be able to comment better on this, but from an observational perspective, there seems to also be an increase in statements from the CFPB about the authority of states or encouraging states or partnering with states that I think is certainly a plan B strategy for more aggressive regulators to get these policies enacted if they can't get them through at the federal level.
Yeah, there's no question about that. I feel like the CFPB's encouragements to states, particularly on the legislative front, what you and Rami were talking about saying, oh, go legislate whatever you want, it's not going to be preempted, is just a response to the fact that there doesn't seem to be an end in sight to legislative difficulties at the federal level. The stars don't look like they're going to align. They're not aligned now and don't look like they're going to align for one party to control the House, the Senate, and the White House such that legislation can be more easily enacted. And so the CFPB is saying, well, if we can't get it at the federal level, just as you said, David, let's have a bunch of states do it. And that started to show some success, actually, as a strategy. You've seen a lot of legislation on the issue of medical debt reporting. You've seen a lot of debt collection legislation at the state level, and you've seen lots of privacy laws enacted at the state level. And, now Colorado is the first to have an AI law, and other states may follow that example as well. So I think the inability for either party to advance legislation like this at the federal level in Congress, it leads to the fragmentation of many state laws that we as an industry now have to deal with.
Then if you connect the thread between the entire conversation we've had, which is the increasing trend in litigation, the increase of post-summary litigants, the increasing use of automation, AI from a litigation perspective, combined with the open issues for Loper, combined with this sort of federal state conundrum and rulemaking, all that kind of stuff, that portends a lot of turbulence over the next 5 to 10 years, no matter how it shakes out.
Okay, well, we're going to buckle up and prepare for that turbulence. But for now, let me thank both of you for being on the podcast today. This has been a great discussion. I know that you two will be back on the podcast again to talk about issues like this in the future. But thank you today for being on. And of course, thanks to our audience for listening in as well. Don't forget to visit and subscribe to our blogs, troutmanpepperfinancialservices.com and consumerfinancialserviceslawmonitor.com. And while you're at it, why not visit us on the web at troutman.com? You can add yourself to our Consumer Financial Services email list so that you can get copies of the alerts and advisories that we send out, as well as invitations to our industry-only webinars. And as I said at the top of the show, if you enjoy our thought leadership content, our mobile app is the best way to access it. It's available for both iOS and Android. Just search for Troutman Pepper in your app store, download it, and give it a try. And of course, stay tuned for a great new episode of this podcast every Thursday afternoon. Thank you all for listening.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.